Testing 1, 2. Are you hearing that in the room? Okay. 2, 2. 1, 2, 3, 4, 5. Can you hear that? Does that work? There you go, sorry about that.
Could we have the other one as well?
Yes, right there.
Two speakers. Will it work now?
Yeah.
Oh, I see. So you made it live from there. How do you manage to do
That's
that?
not that wasn't me. I'll take responsibility for the failure.
Okay. Thank you very
Do you
much.
just want to test that?
So they were switched off from the top.
Testing 1, 2, 3.
Excellent.
Back in there. Just leave that in there so that you're ready to go.
Right.
Okay.
Okay. I'll just do it for the introduction and then I'll give it to
Make
you.
sure that's, yep, and a handheld if you need handhelds.
So they're live now.
Yeah.
Okay. Okay. Thank you
Okay.
very much. Okay, sorry about the delay. It was a technical issue with the microphone, so we needed the techie to do whatever it was from back there. This evening we have a double act coming to talk to us about surveying safely. We welcome Anthony Taylor. Anthony is Director of Group Health and Safety at Bilfinger GVA, and he's also a member of the Business Continuity team. Anthony has delivered consultancy both as a private practitioner and as part of large organizations, working with various industries that include insurance and construction, and also advising building owners. He was a major contributor to the 2011 RICS guidance note, Surveying Safely, and is currently involved in the updating of the note. Michael is a solicitor. Michael Appleby is a solicitor, a partner of Fisher Coggins Waters, and he specializes in defending individuals and organizations facing investigation or prosecution with regards to health and safety matters or manslaughter for acts arising from health and safety related incidents. Mike also acts for clients in a variety of industries, including transport, ports, construction, lifts, manufacturing, the waste industry, and he is ranked as a star individual for health and safety in the Chamber's 2016 and I believe also 2017, so you're still a star. They're both members of the RICS Health and Safety Advisory Group, and they will talk to us about surveying safely over the next 3/4 of an hour, and then there will be some time for your questions. Right, so if we swap, I don't know, we'll see if it works.
Bit more 1, 2, 3. Can you hear? Can everybody hear? Good evening. It's Anthony Taylor. I'm going to whiz through the newer version of Surveying Safely. The majority of what I'm going to talk to you about tonight is actually your own responsibility as individuals. We'll touch on some of the corporate stuff. I'll explain the difference in the last edition of Surveying Safely and what we've done with the new one. The new one should be out in Q1 2017. It's actually going to go out to consultation. If it isn't out already, it'll be out in the next week or two, so your views would be most welcome. The intention is that once we've got the consultation back, hopefully we'll get it out and it'll be published, as I say, in Q1 2017. The difference is this is an official professional statement. I don't know whether you know about them, but RICS have had another look at all the guidance documents that they produce and put them into 3 categories, which I'll come on to in a minute. Well, the official professional elements are deemed, within a professional statement, elements are deemed as an RICS regulation, which means that the elements in here which are deemed must are now obligatory to RIC members, whether it be an organisation or an individual. It's been internationalised in the manner that RICS is looking to try and get international best practice out and across. So the document is generally, all at the front is all principles of health and safety and details, which is hopefully fairly international, but obviously fairly based on UK law, which is regarded as probably some of the best in the world. The actual law element is now put in the appendix, such that if other countries, other jurisdictions want to take the principles and put their own jurisdiction in, they can do that with some ease. So that's the structure of the document. It may, as the last one was as well, given that it's professional guidance from the institution, it may be taken into account if you're ever in a court, whether you've actually adhered to, what have you, with this document. As I said, practice and the guidance is at the front, the legals are in the in the appendix. The RICS have now moved all their documents into either as a standard, which you'll know about, professional statement, which this is, or guidance and information. So a professional statement, sections within professional statements set specific mandatory requirements for members, and they use the word must. And what we've done in the document is highlight the word must to differentiate from using the word in normal English. Where it's not a must, it is a should. Yeah? And again, I'm not going to read all that, but these are the fundamentals of how professional statements are going to be put out. Surveying safety is one of the first ones, so I know the organisation is looking to hear back in the consultation. And any content that does not use the word must or sound is basically is information which you're expected to adhere to, but it's not regulatory. There are 13, lucky for some, regulations set out in the document. And fundamentally, I'm not going to go through all of these, but it's the basis of the organisation must have management systems, you must have management process, people must be competent, the organisations must provide competence training, must do risk assessment, which we'll come back to a little bit later. And indeed, the last two are basically putting in effectively management plans or method statements when you're dealing with hazardous substances or hazardous conditions. But these are what they're deemed the regulations. So those that haven't seen them before, at the front of each chapter of the document, elements of these will be put at the front in a table of each chapter, and the detail of what sits behind the regulation sits within that chapter. Right. As I said, I'm going to speak mainly about your own personal responsibility. The first one, coming from the point of a health and safety expert, is I try and get across to people, health and safety is actually your responsibility. It is a common thing in this day and age, particularly with the society we live in, where everybody tends to assume someone else is doing something. So it's someone else's responsibility. And I'm trying very hard, indeed a lot of the guidance in the document is saying, look, we're all responsible. In particular, you're responsible, the best person to look after yourself is yourselves, for obvious reasons. Because no one's going to be sitting on your shoulder when you're out on a moor or in a building or in a cellar or whatever you happen to be doing. If you're supervising others, you have a wider duty of care. You're responsible for them as well. Now, that'll come out more in the law, and we'll talk about duty of care in a wider spectrum in a little while. It's incumbent upon you to maintain your competence, skills, knowledge and experience, hence you're here. It also, this new edition introduces the safe person concept. That very simply means that if everybody takes personal responsibility for themselves and they remain safe, then reasonably, if everybody remains safe, then nothing's going to happen. Yeah? I'm not going to go into detail. It's in the document, but it's very much trying to get people to take responsibility, to do the checking, to make sure that they obey the rules, make sure they put on their PPE, and so on and so forth. So it's looking after yourself and indeed your immediate colleagues. Very important always never to exceed your competence. Part of competence is to know when you reach your limit. A lot of accidents, injuries and things happen when somebody thinks, oh, I think I can just do a little bit more. I've got a bit more experience than I thought I had. And that can be very, very dangerous, both personally and in legal terms. So don't ever exceed your competence. Part of competence is knowing your limits. We also introduce, and I'll come back to the dynamic risk assessment, that's basically the last chance scenario when you're actually on site, is to give you is to try and encourage people to take a last minute look at what's going on around them to make sure it's still safe. But I'll come back to that. Ask or employ appropriate expertise. If you're not sure of what's going on, ask. Don't try and do it or assume or prod someone else into doing something. Go and ask and get the appropriate expertise. It's a legal obligation for the organisations to have that available. And you probably, 90% of you will probably have it sitting in your organisation somewhere. But ask beforehand, not after. Review required competence of your line manager regularly. I mean, again, it's particularly in large organisations, when you come to annual assessments or what have you, often people forget to look at what they're going to be doing next year to make sure you're prepared and you have the training to do that, whatever it is going to take up with next year. It's a legal requirement for you to cooperate with your employer. Again, I'll come back to that in a minute. It's a legal requirement to adhere to corporate and company policies and procedures and report any dangerous situations. I mean, don't walk on by. I've stuck at the bottom here, Hero's Law. There has been quite a lot of furore in the papers a while ago about good Samaritans helping people on the street and getting in trouble because it went wrong. There has been a law now, or there's certainly precedent, I think, rather than a law, that says that if somebody's genuinely trying to do some good for somebody who's got injured, and it doesn't go quite as well as they planned, they're not going to get in trouble. So it really is to encourage people to help where they can do. But what I'm saying about don't walk on by, if you see something dangerous going on, tell them to stop it. But if they won't stop it, which is not unusual, don't you get involved. You know, walk away. If you feel the hairs on the back of your neck go up, it's probably a good sign that you're not comfortable with it. So walk away. Very quickly, the law, and I'm not going into it long, it is the duties of every employee while at work to take reasonable care for the health and safety of himself and other persons who may be affected. That is the fundamental backbone to the health and safety law as it affects you as individuals. The B is, the other fundamental is that you're obliged in law to obey what the company asks you to do in fulfillment of their obligations. I put PPE there because it is an obligation. If you're given PPE, organisations are obliged to give you PPE to make sure that it fits, to make sure that, on the other hand, you've got to wear it. And a lot of people take this stuff, they take it ill-fitting, and actually ill-fitting PPE can be even more damaging because you might be assuming it's protecting you from something when in fact it isn't. So make sure, if you have to wear PPE, it is the right PPE and you wear it. Another situation, in a lot of the regulations you may come across, depending on what part of the business or industry sector you're in, are the term responsible person, authorised person, competent person, person in control. These all have a higher duty of care, and they're assumed that the person who takes that responsibility, and these are individual responsibilities, although corporations will have them as well, that if you accept that, you're expected to understand what you've taken on. So if somebody asks you to sign something, or you're looking to take somebody on as an authorised person or a responsible person to do something, and these are terms in law, make sure they are competent to do it. Similarly, of course, if you are. Corporately, organisations are required to have an appropriate management system for health and safety. You will have heard of OSAS 18001 and ISOs and various other ones, but it doesn't have to be a certified one, it just needs to be a system to manage health and safety. That will tend to be things like arrangements, a policy, methodologies for managing the work that you do. They are obliged to provide safe systems of work. Now that obviously relies on somebody sitting back and having a look and trying to work out what the work is and engaging with those involved, and we'll come to risk assessment in a minute, to make sure that the systems of work that they're undertaking are safe. And in fact, most of the prosecutions that come are successful from HSE is when people have done some work and it's patently obviously that it was unsafe to start the job. Information, instruction and training, I've mentioned the organisations are obliged to provide that for you. Appropriate line management and monitoring. The organisation must monitor that what they've set out in their policies and procedures are actually monitored, and that should be going on. You'll probably have people like me creeping around doing audits and ticking boxes and so on and so forth, although I don't agree with ticking boxes. But it is incumbent on the organisation to make sure the rules it sets are being obeyed. Another thing is to manage health and safety in the supply chain. Competent contractors, a lot of you will get involved with that. I'll touch on that a little bit later. But it's incumbent on the organisation to make sure that those that they employ to contract to do X, Y and Z are also competent. Now, identify and management of foreseeable risks. I'll come back. The important part there is foreseeable. And Mike will talk about foreseeable at the end of it. And then consider the legalities in different... If you work for international organisations, there are differences in the law locally, although the principles will be much the same, particularly in Europe. But there are cultural differences, different attitudes to where these things where these things are taken on, and one needs to be careful to take notice of them. There's obviously a moral obligation on corporations to look after both their people and the people they deliver their products to, whatever that product might be. That's generally, as far as you guys are concerned, dealt with by having employers' liabilities. If you get hurt, that there is some insurance to cover it. And obviously, corporations have a significant risk of reputation. You will know about the Alton Towers and various other things which are directly related to health and safety incidents that have put people off using whatever the product these people are. Individually, of course, if you're found to be wanting in health and safety, if you're fined or jailed or what have it will have an effect on your personal career. So, these things do matter if they go wrong. Corporate reputation, of course, certainly the larger organisations are very keen now on corporate social responsibility, of which health and safety is but a part of it. Within RICS, we've got all these various different groups and professional bodies and what have you, but they will all have slightly different risks that sit within the professional disciplines. One of the main ones that we come across all the time is lone working. Lone working means, just to be absolutely clear, is when you're on your own, out of earshot of anybody else should something go wrong. Now that could be, it doesn't mean to say you're alone from your colleagues. It could be literally alone at the end of a runway, or at the top of a roof, or in a cellar. Or it could in fact be when you're going to perhaps, I don't know, collect the rent or go and survey some building where it's in a less than hospitable area of town, and actually you've turned up in a suit and everybody else is not in suits, and take objection to it. So one needs to, and all organisations should have in place a lone working system, generally a buddy system of one form or another. Do people know what I mean by buddy system, generally? Yes, no? Basically, before you go out, tell a couple of people where you're going and when you expect to come back. So that when you come back, you ring them, and if you don't ring them and tell them, that they can set an alert out. It's as simple as that, and it's about the most efficient way. There are obviously very different risks between whether you're working in rural areas or urban areas, whether you're working with the machinery and business assets, whether they're working, whether they're not working. Minerals and waste, if you imagine slurry pits and quarries and Lord knows what. So they're very different risks dependent on the industry sector that you're working within. And given that a lot of your surveyors, you might be in and out of all sorts of different sectors. So, one of the points, I'd ask you to do is the preparation, is looking at and considering the sorts of things that might put you at harm before you go to site. Yeah? Residential, there are all sorts of rules and regulations around that. In fact, there is a publication that was put out at the beginning of this year, which is Health and Safety for Residential Property Managers. That's published by RICS, which goes into considerable detail, and I think it's actually quite a good document for those of you involved in any residential property. Construction refurbishment sites, a lot of you will be on those. Those are actually tend to be fairly well run if they're under the the governance of a decent principal contractor. Much of the danger of construction in the wider sense, you know, in the sense that the law defines it, are on the smaller jobs, or where there are refurbishments that just have just slightly slipped by. I know of occasions when, you know, gone in and perhaps a tenant stripped out a first floor, and you've all sorts of bits of electricity or other utilities hanging out of the wall that haven't been properly turned off. So it's not just construction sites. Refurbishment sites are often more dangerous than the others because they're quite often less well managed. And arts antiques, again, those are completely different things. All sorts of chemicals and what have you that will work with that, and a lot of manual handling, I'm led to believe. So it's very important that whereas companies and the law accepts generic risk assessments, they're not necessarily enough. You need to look at actually the job in hand, what you're trying to achieve, and use the basis of a generic risk assessment to make it rather more task or condition specific. Yeah? And again, I come back to the dynamic risk assessment, the last thing, which I'll come back to, which is, again, the last minute thing. When we're talking about risks, within the health and safety world, it's never the intention to provide risk-free environments. It just doesn't happen. It's never going to happen. What we're looking for is significant risks. Now, significant could be different, and it's different to different people. So that's the language used in law. But the point of it is really to try and get people away from having miles and miles and miles of lists of things which basically you do at home anyway. And all it tends to do is to snow or cover the significant risks up in a flurry of nonsense paperwork. So the important thing is to look at the significant stuff and make sure everybody knows about it, and to put in controls and safe methods of work around those. The more dire the consequences, of course, the more detailed the assessment of the risk needs to be. So if you're taking on a far more obviously risky job, or one thing or another, you've got to do more work in the preparation of the work beforehand and the assessment of the risks. Suitable and sufficient, which is the other term used within the law, it really means that a proper check was made. Someone's actually done some work on this, not just copied the last one, put a new date and a new address, and I've seen it often enough, and I'm sure a lot of you will have done, and just pass that on. That is not suitable and sufficient, or a proper check. You need to ask and have a look around who may be affected. It could be the general public, could be builders, could be the guy, the neighbour next door, because you're doing work, and they may be doing work as well. So do the two sets of works conflict? You need to deal with it, identify and deal with the significant hazards, and the precautions need to be, you know, reasonable. And again, coming back to foreseeable, you can only foresee so much, and it needs to be reasonable. And as long as the risk is low enough to be acceptable, yeah, to the man in the Clapham omnibus. I don't know if you've heard that expression, as in the the public. HSE have written a guide to controlling risks in the workplace. I won't go into that. They're actually beginning to revise it, and they're looking at that. I'll come back to that in a minute. Risk management generally, and this is sort of wider thing than a specific risk assessment for a particular task, is looking at how, you know, how things may deviate from what you're looking for. It could be better or it could be worse. Yeah? So the trick with risk assessment is to make sure that you have identified the risks, yeah? And then control them, that's all. It doesn't mean that they're necessarily bad or particularly good, but as long as you've identified them, you've got half a chance of controlling them. If you don't bother to identify them, then they're going to be uncontrolled, and that's where the danger sits. Dealing with them and actually undertaking the assessment of risk, obviously need to be competent enough to understand it. You know, so people who may be doing work at heights with electricity need to understand what electricity, or if you're using trying to fiddle with high voltage, people need to understand what the discipline is that they're dealing with. They need the competence of it, and you'll probably know that there's hazard and likelihood equals the risk. Yeah? The changes being made to the HSE document are quite interesting. Very little, basically. What they're actually aiming to do is to remove some of the giant amounts of paperwork that come by and actually focus in on the significant stuff. And what they're interestingly now saying is it may not be a bespoke document, part of another management process, so it hasn't actually got to be written down any longer. I wouldn't suggest you don't write down significant ones, but you know, they're taking a much wider view of what this means. This is out of consultation at the moment, so it hasn't passed into law. They have identified that it tends to be business making, or at least their point, HSE are pointing the finger at businesses really and saying that business makes it more difficult for other businesses by demanding more and more paperwork. There is an element of truth in that, in the fact that each business is trying to move liability down the train, you know. But HSE are trying to put a stop to it. And the emphasis is on trying to control risk and risk assessment as being business as usual. Health and safety should not be an enormous bubble. You know, it has done for many, many years, sat outside as health and safety. And I'm really keen just to say, which, you know, it's health and safety. It's just one of the other things you have to deal on a daily basis. But as long as you keep your fingers and toes on, you go back to, you know, go back home at night, you've probably done all right. It's not difficult. There are technical issues, which is why you need to get advice, but when it's necessary. But the emphasis the HSE and people like me are trying to do is just, it's business as usual. You should just consider risk to health and safety as part of any other job or project that you're looking at, just as a normal thing. Dynamic risk, I said the last chance. The concept behind this is just before you've done all your work, done all your exercise, done all your planning, done everything, and you've turned up on the site and actually it's changed. You know, things do. If you go to a construction site over a period of months, it goes from the footings through to first fix, second fix, and so on and so forth. So the environments change. The idea of the dynamic risk assessment is that just when you turn up, before you walk through the door, is sit back for a minute and just have another look round and just check that it's still as safe as you thought it was. And if not, make adjustments to your behaviours or PPE or whatever you happen to be doing. While the job is going on, you know, maybe a new chap's been brought on with a new bit of lifting equipment or something. You know, even while the job is going on, keep double checking that the environments are safe, you know. And that's all it really means. The fundamental one being, if something does go seriously wrong, can I and everybody else get out of the way? Yeah? So it's not a grand thing, it's just a common sense. Just keep scanning your surroundings while you're working in them. Excuse me, just get a bit of water. Right, when you're considering the risks, consider the physical location where your work's being undertaken. Again, it will change wherever you happen to be. If you're in an office doing one thing, or if you're on a railway track doing something else, the circumstances are entirely different. You need to consider those. Hot and wet and chemical, you know, depending on which environment you are in. One of the fundamentals which I'm very keen to get across to people, my perception of a risk will be very different to every single one of yours, depending on, you know, our gender, how old we are, how much experience we've got. And people forget, you know, it's becoming a much more important thing in health and safety now is behavioural safety, which is basically recognising every single person has totally different views of risk because of their life experiences. So when you're doing stuff, or particularly when you're sending others out to do stuff, consider whether they are actually suitable to do it. Yeah? Particularly what often gets forgotten is that you might have an experienced old lag like me who turns up, but actually if I'm into a new environment, I won't understand that any better than the guy who's been sitting there doing it for years. So just make sure that people think. And the geographical location will, of course, have different risks associated with it. So there's quite a lot to consider. Occupational hygiene and health. Occupational hygiene is basically the science sitting behind it. So when you're looking at pesticides or asbestos or details or dusts or this, these are the guides who will try and work out how to make sure that the danger can be minimised or subverted or eliminated. So that's what the occupational hygienist does. Occupational health considers the sort of physical and mental things that happen at work. And I've just put a quick list there. You know, sun protection, environmental factors, hand-arm vibration, noises are physical or harm-inducing. So that's just simply a quick brief of what the difference is. There's a bit more about it, about all of this, of course, in the document. On arriving at any premises, any site, look up and try and get as much information about that site or project or whatever it happens to be before you go. Now, ask. The people who are employing you, the people who own the site, the people who are in control of, the person in control of the site has an obligation to make this available, this data available to you. It's often there, just that nobody asks for it, and if they do ask for it, they frequently don't read it. Buddies and lone working, indeed, on occasions it's worth checking who you're actually going to meet exists. Particularly, I mean, a lot of you may remember the Susie Lamplugh, who was the estate agent who went off to see a client and never came back. Consult with colleagues, reaffirm your competence to do the job and the competence of the people that you're taking with you to do the job, and indeed the people who you might be working with, just to make sure that you haven't got people who are obviously totally incompetent. And travelling to and from, the one I'm going to talk about is when you're driving. There's a lot of discussion in the papers and the law at the moment about driving and using of telephones. It's pretty obvious that it's distracting when you're on a mobile phone, yeah? And it's now illegal. It's not so well known that actually the hands-free kits are more distracting. It's the way the mind works. So all I can do is implore you, do not use telephones when driving. Because you'll either, at some point, you've only got the slightest little distraction and there'll be a catastrophe. I wouldn't be at all surprised to see hands-free kits made illegal soon anyway. But it's patently obviously that if you're talking to somebody else, it's going to be distracting, and when you're distracted, accidents happen. On site, when you turn up there, consider all these sorts of things: contaminations, residual, if you're out on farmlands, residual pesticides, all sorts of contaminations, and all the usual sort of stuff. Unguarded edges, don't forget, of course, you can fall into things as opposed to, fall into holes and excavations and slurry pits and Lord knows what, as opposed to falling off ladders. People forget working height also means actually below ground. Animals, slurries, settling pools, heavy vehicles. These are typical, particularly on construction sites or mines and quarries, or indeed if you're working in the transport area where you might be dealing with trains or aeroplanes or such like. Site rules and induction emergency, always listen to those because they will be specific to the site you're dealing with, and consider carefully if there are any special risks or restricted areas. Don't go in them unless you're escorted. Yeah? Competent resources, managers and contractors. There are a number of things here, which I think you've got in your notes there, which give guidance on how to check out contractors. There's quick ways and other ways. Don't forget that health and safety is but one of these things you need to do due diligence on. There might be environmental aspects, there might be waste aspects that your company needs to consider. It's just that it's very important to set out very, very clearly the rules of the tendering. I mean, the Bribery Act and all these other things come into this sort of stuff. But it's also worth talking with the contractor about the project, because actually, if he's the expert or there's a selection of the experts that you're asking to tender for the project, they probably know more about it, might give you some value-added stuff before you put it into the final tender document. So well worth talking to contractors before actually signing them up. You can also check on any previous enforcement. There's a health and safety website just to make sure these guys, the people you're contracting to, you probably ask them whether they've done it, but it's worth checking that they told the truth. And I said get a signed contract. You'd be horrified to see how many times I see work going on without a signed contract. And one of the reasons I say that, you cannot contract out of health and safety, but you can at least share the joy by getting other people to take responsibility for some of the liabilities. CDM I won't go into. Competence, of course, you need to monitor them. Once they've got the job going, you need to monitor what they're up to. Just leaving them, letting them run, it does not negate your responsibility for their behaviour. In particular, subcontracting. It's very often out there are people, subcontractors. And by the bottom, you need to check that people making sure that their subbies are doing it as well. As always, make sure emergency routes are organised and kept clear. And very lastly, your duty of care, which Michael will come back to. If you're in a your duty of care is primarily to yourself. I repeat, no one is better at looking after yourself than you. The only person who's going to get really hurt is you, and of course your wife, girlfriend, children, or what have you. And if you damage your back or your arms or something, it is you who's going to you're going to suffer the consequences. If you're in a supervisory role, you've got higher duty of care. If you've got residential, if you've got people living above something, obviously there's a higher duty of care because they're asleep, you know, which means that they're not as alert as they would be if they're in an office. If you're working with the vulnerable people, again, as a competent person or as holding yourself out as a professional, you have a higher duty of care than the average Joe public. And even if you suggest that you haven't, the courts might say that you have held yourself out. If you hold yourself out as competent or a professional, then the courts and the law will expect you to pick that responsibility up. Over to you, Mike.
Thank you. Can everybody hear me? All right. I haven't gone beyond my level of competence of putting my microphone on. Before I start my talk, I just wanted to pick up on something that Anthony said, which is, you know, health and safety can sometimes be seen in a bubble. One thing I've heard another guy say, who does health and safety I lecture with, and he says, you know, well-managed companies manage safety well. And I think that's the thing. If you see companies that are managing other things well, then they're likely to manage health and safety well as well. The first thing to say is that obviously what Anthony's been telling you about is the new Surveying Safely. And that sets out how you go about surveying safely. What I'm going to talk about is when things go wrong, and you know, what the courts, how they can look at things. The first thing to appreciate is who investigates incidents, and I think that quite often it comes as a shock to people who investigates. If there's a fatality, then all fatalities are dealt with as a manslaughter investigation first. So what you have is the police, with health and safety assisting them investigating the case. They are investigating the circumstances. If the police decide there's no manslaughter, so no manslaughter against an individual, no manslaughter against a company, then the case is passed over to HSE. And the inspectors from HSE on a construction site, obviously other bodies, say if it was a railway, that's the Office of Rail and Road investigate, but in terms of most of the investigations on health and safety, it's HSE. Now, the thing to appreciate, particularly with the police, is that they have, you know, they won't understand your world because they're normally dealing with what they call serious and proper crime. So quite often the challenge is trying to get the investigators to understand the context of what the case is about. Because I heard a lecture by a very senior lawyer for the Crown Prosecution Service, and her advice to the police officers that she deals with on manslaughter cases about whether it's a bad failure is she said, oh, if you look at an incident and there's a sharp intake of breath, then that's corporate manslaughter. Well, I think that's a rather simplistic view. Well, one of the problems, I don't know whether any of you have ever come across a very old American comedian called Danny Kaye. And there's a story where he talks about a woman he doesn't particularly like. And he says of her, you know, that her favourite position is beside herself and her favourite sport is jumping to conclusions. And quite often you can find perhaps some of that mentality amongst those that investigate, simply because they do not understand your world. These are the main offences that you're looking at. There's corporate manslaughter. And as you see, corporate manslaughter is under the Act, and it's where death was caused by a gross breach of duty by a company that was substantially due to senior management failure. So what the prosecutor can do, can take a number of different people, look at their conduct, look at the way they dealt with their job, and he can add those failures together to get what they call a gross failure, a really bad failure. So that's against companies. For health and safety, then I'm probably sure that you all know about Section 2 and 3, the duty to ensure, so far as is reasonably practicable, the health and safety of employees, that's Section 2, and non-employees, so that can be contractors, members of the public, that's Section 3. And it's also worth mentioning Section 4, which is a failure by those that have any extent control of non-domestic premises to ensure. And then there's those magic words again, so far as reasonably practicable, that the premises are safe and without risk to health. The other common prosecution that normally, sometimes it's on its own, but it quite often is part of the bigger picture, is what the prosecution say, the failure to carry out a suitable and sufficient risk assessment. And quite often, Anthony was talking about what's foreseeable, what's reasonably foreseeable. One of the things you find with prosecutions is when there's a death or a serious accident, the prosecution turn around and say, well, that was pretty foreseeable, wasn't it? Because it's obvious. And in life, as you know, when something goes bad, it's obvious afterwards. But actually seeing those things, quite often when you have a bad disaster or you have a bad situation, it's not one thing that goes wrong, it's a number of different things that go wrong, all added together, which, if one of those pieces of one of those ingredients had been missing, then you wouldn't have had an incident. And of course, for your type of work, the other area of prosecution is CDM 2015. As Anthony was saying, in surveying safely, the purpose of the document is to try and give, advice and guidance, for not just for the UK. And so, because of that, although the UK law sort of guides the way in which the document's been put together, the law is actually in the appendices. And I think I've got this the right way round. It's Appendix 1 is guidance on CDM, and Appendix 2 is general guidance on the law. So most of what I'm going to be talking about is Appendix 2. One of the leading cases in health and safety is Shargo. And I've put a little quote there, and you'll see it says it is not the purpose to impose burdens on employers that are wholly unreasonable. Its aim is to spell out the basic duty of an employer to create a safe working environment. So therefore, the courts are not expecting a perfect world, but they're expecting you to take reasonable care. As I've said, there's more guidance on CDM in Appendix 1, but I thought it's just worth mentioning the duty holders. You'll know this. There is now in CDM 2015 more of an emphasis on the client. Whether in reality we're going to see more prosecutions of client, I'm not convinced, because the mindset of most prosecutors is that when things go wrong, they look towards the principal contractor and the contractor and those that are working with them. You will know this when CDM applies. As we're running a bit short time, I'll press on. HSE have if they see something that they don't like and they're concerned about, then they can serve enforcement notices. Now, there's two types of notices. There's an improvement notice where they're saying, basically, you're in breach of the law and we don't think you're going to do something about it, making things better, unless we serve a notice on you. And they will serve a notice giving you a period to get your act together. Now, I've had cases where HSE have simply misunderstood the risk, they've misunderstood the work. I've actually had one case where an improvement notice was served on a client where if it had done what the HSE had said, they would have been in breach of a British standard. So, don't just assume because you've been served with a notice that it's right. Sometimes it can be done by negotiations with them, saying, look, I don't think you've properly understood, because they can withdraw an improvement notice any time up to the time when they say you've got to comply. With a prohibition notice, this is where they see a real risk, a real danger. So they want you to prohibit doing something. If they serve one of those on you, then I'm afraid even if you appeal, it's not, you've still got to comply. It's not until the appeal is heard, you know, can it be withdrawn. Only a court can withdraw a prohibition notice. Sometimes through negotiations with the HSE, you can say to them, look, you haven't quite got this right. And so I've managed to achieve where you've got them to sign a consent order to allow the court to withdraw. Remember, it goes to an appeal tribunal, and the time limits are very strict. You have to get your application in very quickly. Fee for intervention, you probably know that now HSE are under a duty to recover their costs of investigation. I've put the details there. Can I just say this to you? If you get served with a notice of contravention, do read it carefully, because it can quite often, it sets the scene of how they're looking at an incident and what they think. And I think too often people do not challenge them. It's a matter of just simply writing a letter. At the moment, there is an ongoing judicial review of their appeal process as to whether it is fair or not, and that's going to be heard next May. I know that because I'm the lawyer doing the judicial review. But the important thing about this is I think too often companies just sit there, accept what's said in the letter, and you know, we still don't know exactly how that might be used in evidence. I've had cases where, you know, the prosecution papers have been served and their notice of contravention are there exhibited in the evidence. So if they've got it wrong, then you should challenge. I've also had cases where duty holders involved in the same incident have been served with fee for intervention and notifications of contravention. And if they all tried to comply with what HSE wanted, then they can't all comply because the notices are just, they're just not compatible. So do be careful on that. Now, obviously, the thing we're concerned most of all is about individuals. There's gross negligence, manslaughter. That's where you've got a duty of care. Invariably, you know, in these circumstances, it's quite easy to prove duty of care. That you've breached that duty of care, you've done something wrong, but that breach is so bad, it's so terrible, and it is a cause of death. Not the only cause, but a cause of death. Section 37, this is for directors and really senior managers, and it's what we call secondary liability. And it's where if a company has been in breach of its health and safety, then HSE can look further to the very senior manager or the director and say, actually, they have in some way contributed to the way in which the company has failed. And it can be by three ways. It's due to consent or connivance. So consent is where, you remember Anthony was saying about don't walk on by. Well, this is where you'll see something going on, it's not right, but you don't challenge. That's consent. Connivance is where you turn a blind eye. And attributable to neglect, that's the usual line they go down. If you can think of it, that's where within your role, you've done something where you failed in your job and that has caused or that has contributed to the company failing. What that really comes down to is duty of care. And Anthony's already mentioned Section 7, so this is for employees up to, you know, quite senior management. You know, you've got a duty to take care of yourself and, you know, through your job of others. So it's basically if you're negligent. But to be prosecuted under this, you've got to be criminally negligent. And I think just giving you a broad brush, a broad idea of this, if you're a frontline worker, then you've got to be really, really negligent to be prosecuted under Section 7. But the higher you are up the management chain, then the less negligent you have to be to come within this breach of this regulation. And it's as Anthony was saying, you know, the more responsibility you take, the higher duty there is expected of you. But what is also important, and this is something that HSE and the police often fail to understand, is the extent of someone's duty. And this is a case, Caparo, where the court, it's a civil case, looked at what do you need to do. and it's about the foreseeability. So how obvious was it that the way, you know, that your job, if you didn't do it properly, could lead to something going wrong? There's got to be some proximity between you and the eventual, you know, where the damage, the person that got injured. So there's got to be a real connection. So you can't be, you know, over in the management part. I had a client prosecuted last year for Section 37, where he was an operations director. He wasn't a statutory director, but he got the name director. He was in charge of a project. And basically, HSE was saying, well, he should be checking all the risk assessments and all the method statements. Well, that's ludicrous. That's not his job. He's delegated the proper. It wasn't that proximity. And then the other thing, which is a very much lawyers' talk, that if you're going to impose this duty that you say they've breached, that has contributed to the company's failures, then it's got to be fair, just, and reasonable to do so. You probably know from what you've seen in telly, and Anthony mentioned Alton Towers, that there's now new sentencing guidelines for health and safety offences and corporate manslaughter. Interestingly, the guidance doesn't cover individual manslaughter, but it certainly have an impact. And what you've seen there is that now the courts are expected to look at risk. This is not something that's just happening in this guidance. It's in other types of sentencing guidance as well. But the problem is the courts are being asked to look at risk, and I'm not sure that they're actually equipped to do so, because understanding risk in your world takes a bit of knowledge, takes a bit of appreciation. So what they're looking at is the risk of harm. So, you know, it may not have been a death, but if it had the potential to be a death, then you're a category 1 harm, right? The other thing is they look at the level of culpability. And when they've got that, for a company, there's a sort of matrix, and they look at your turnover, and that determines where the starting fine is going to be. And then if you've got aggravating features, it moves up the chain. If you've got, say, for example, a good safety record, you've never had a previous conviction, that's good mitigation. You move down the bracket. But, I mean, as I say, risk is really hard for the courts to understand. In the Alton Towers case, I know that there was some debate in the court about risk. And what the defendants were saying is that this ride, the Smiler ride, had over 3 million rides without any incident. You know, this means that what happened, it's like another of those cases, a number of things that went wrong, albeit not very good, that people were overriding the safety features of the system. They're saying it's really, and the judge will say, no, there's been a terrible accident, the risk must be high. So, as I say, that is really difficult to get across. But I think with more concern, which is in terms of for you guys, is that for individuals being sentenced for manslaughter, I'm afraid the threshold of when someone goes to university, the threshold when they go to prison has been lowered, and that's, I think, of concern. Just a bit of advice here. If you're asked to be interviewed or want a statement, find out on what basis. Are you down as a witness, right, or are you a suspect? Because if you're a suspect, you want representation. I've had cases where individuals have been dealt with as a significant witness, and then the prosecution try and change their mind and have them as a suspect. You do need advice there, so be careful. I mean, the best bit of advice is if you're ever involved, you're involved in an incident in some way, and people want to interview you from the police or from the HSE, ask, am I a suspect or am I a witness? Funding is becoming a big issue. Legal aid is very limited now. And if you're privately funding, I don't know whether you remember, there was a case of I think it was the chief whip of the Conservative Party. He was prosecuted over allegations of rape, and he was acquitted. And he ended up with a bill of £130,000. It was his life savings. And he was absolutely shocked that he could not recover his costs, even though he was acquitted. What I think was rather ironic was that he was one of the MPs who voted for the change that stopped you getting your costs back. Also look at insurance cover. You know, sometimes one of the things you ought to be saying to your employers is, if I got into, who would pay my costs? Well, I've got insurance. It's a big question to ask. I was doing a lecture a couple of months ago to some engineers, and one engineer said, I went along, he's a very senior guy, I went along to ask my employers that very question, and they said, I've got a D&O policy, directors and officers, and I'm sorry mate, you're not important enough to be covered by this insurance. The other thing is when they do get insurance is people forget you actually have the right to the lawyer of your choice. So a lawyer, get a lawyer who knows what they're talking about in this particular area. Don't get fobbed off with the fact that the insurers say, no, you've got to have one of our panel guys or whatever. You know, that is not right. You can have the lawyer of your choice. Quite often what a lot of companies do is they will, you know, have lawyers that they can ring up that are independent to their own lawyers. You know, and quite often it's a good idea to listen. You know, because sometimes there's a lot of concern. You know, well, why is my employer saying this? You know, surely there's some kind of stitch up. Quite often it's they just want you to be, you know, represented by another firm solicitor, but who they know how to do this area of work. So that's just a little quote. I just wanted you to think that I was well read, and so I quoted Albert Camus, and that's a little thing about getting a lawyer. I once represented a train driver, and it was over an alleged sexual assault, and it was one of the most oppressive interviews I ever saw. And I said, "Why didn't you get a lawyer?" And do you know what he said? I don't know whether any of you remember the police programme, The Bill. Yeah, he said, "I've watched The Bill. You only get a lawyer when you're guilty." Well, that's a different view. One last thing, just a little story. I'll tell you about a case of Sidebottom, which I think is very important, and please listen to it. Mr. Golding was a health and safety consultant, and he was employed, he was contracted to provide safety audits, safety visits by a firm called Sido. And Sido worked on a number of properties doing refurbishment, and just like Anthony said, that is quite often the area where you find there's the most things that go wrong. And they were doing part of the work. There was a number of different contractors in this old Victorian property. And Sido was there doing, they were digging some trenches, and they were in the basement. Mr. Golding, as I say, was contracted to do health and safety visits. He was contracted to turn up for half a day a month. He went along to initial site visit before it started up, and they agreed the kind of things they wanted. They wanted help with doing a method statement for the excavations that they were going to be doing. His first visit was something like 6 weeks before the fatality. He looked round, they discussed the method statement, and he provided, with discussions with them, he provided the methods, drafted the method statement. His next visit was 4 weeks later, 9 days before the fatality, and his main concern when he turned up there was the interaction between the different contractors. They were getting in each other's way, and he gave a few toolbox talks. Now his view was, well, you know, I didn't see any excavation that I had any great concern with at that point. Now, as you all know, construction sites like that change not just on a daily basis, but on an hourly basis. There was a poor individual was in there, and the trench collapsed, and he died. He was interviewed by the police. Someone said to him, "Don't you think you should take a lawyer along?" He said, "No, I'll just tell him, what did I have involvement on? You know, I was there half a day a month." The police showed him the excavations, the pictures that they'd taken after the fatality. And his response was, "Oh my God, that looks terrible." So this was then translated back to he didn't do his job earlier. Okay? The other thing that transpired was that the method statement he drafted was not being followed at the time of the incident. And I said to you about, investigators, they jump to conclusions. He had the title of health and safety, but he must be responsible because there's been a health and safety failure. He did a bad interview under caution, didn't have representation, and I understand he wasn't very good when he came to give evidence at court. And that man was convicted. Now, the sentencing guidelines I told you about? Well, this consultation had been published. And the judge said, I've seen the consultation on the health and safety guidelines. And the barrister for the health and safety advisor said, yeah, but they're not in. So he said, well, it's something I can take judicial notice of. He was sentenced to 9 months imprisonment. There is this thing now with HSE and police where they are looking at individuals. I don't want you to go home and have nightmares. Please don't do that. But there is this change where they do tend to look, particularly at more senior people, at what they might have done right, what they might have done wrong, and start jumping to conclusions. So it's a cautionary tale. Ironically, just to finish with a little story, which is, I'm told, I hope it's true, that when he was in prison, he discovered some electrical stuff that needed pat testing and a few other things. And he mentioned it to one of the warders. He said, thanks Richard for telling us about that. And the next thing he knew, he was hauled up to see the governor. So he went to see the governor, and the governor said, I just wanted to tell you, thank you very much for pointing those things out. He said, I see you're being released soon. And he said, yes. He said, well, there's a health and safety job going here. I hope that story's true. Anyway, I think I've run out of slides. Yeah.
Thank you very much.
Thank you.
Please join me in thanking Anthony and Michael for the lecture. Now, we started a bit late. We ran over a little bit, so I suggest that if you have any questions, do you mind if they come to the front and ask you?
No, come.
Okay, so if you have any questions, please come to the front and ask them. You can leave the feedback forms either on the lectern or here on the table. Thank you. Right, you probably have some customers, so you better go and answer the questions. Thank you. Thank you. Whatever. Just leave it there. I'll collect it.
Oh, yeah, that's what they were playing about.
No. I'm going to put this. Here you go.